Thank you very much for your kind words, Dr. D'Alvarez. And before I start, I do want to note that Dr. D'Alvarez has formally retired from the department. We will not allow him to leave, however, and so he is still teaching a class for us, and I'm sure will be, as he is still directing a number of dissertations over the next few years. But please, I would like you to thank him. This year is his 50th year. Is that right? At the University of Dallas? This year, I think? Yes. So please join me in thanking Dr. D'Alvarez. We will have a more formal occasion to thank Dr. D'Alvarez in the future. Well, at the outset, I suppose I should say something about the title of my address. I'm not actually going to talk about the physical possession of the parchment document itself, nor am I going to talk about who, if anyone, possesses the copyright to the text of the Constitution. Interestingly, the Constitution extends protection to copyrights, but itself was, of course, the product of imitating, in many aspects, the state constitutions already in place. The topic I do wish to address is really who runs the Constitution, or more practically, who runs the government that is in large part the product of the Constitution. The consideration of this question was prompted by a number of recent events or debates in the American political sphere, many of which seemed to turn on the question of who was going to take responsibility for what had occurred or what had not occurred but should have. Think of Benghazi, the IRS scandal, Fast and Furious, wiretapping of journalists, etc. A thread that runs through each of these matters is the question of who in the government will claim responsibility for what took place in each of these affairs, or who will refuse to take such responsibility when they ought to do so. Allow me to begin by drawing upon an argument you're all familiar with, found in Alexis de Tocqueville's Democracy in America. Tocqueville sees a grave threat to the success of democratic government in the rise of what he calls soft despotism. Soft despotism, he identifies, as the combination of governmental centralization and administrative centralization. Many modern readers of Tocqueville think that perhaps that feared centralization has in fact materialized in the rise of the modern administrative state, blossoming especially in the post-New Deal era. There is certainly something to be said for this claim, indeed much to be said for this claim, reflected in particular, as it is, in the massive expansion of the federal government, expanding in size and scope into virtually every aspect of American life. Try to think of one that it has not expanded into. It's a nice test. But perhaps this is not, in fact, an entirely satisfactory account of what Tocqueville talks about. That is, what Tocqueville foresaw was the danger of centralized power, such that control over domestic and foreign policy would be united in the same hands at the national level, undermining the liberty of local entities, both public and private, an independence that he understood to be an essential aspect, or the essential aspect, of maintaining a free society. Yet we might ask whether this is in fact the best description of what we actually find in the modern state. Allow me to illustrate what I think is more emblematic of today's politics, found in two examples. One is the IRS scandal that broke this past spring, in which we discovered, mirabile dictu, that groups which were opposed to the re-election of the president had had their application for tax-exempt status routinely delayed, in many instances until after the 2012 election had taken place, surprise of surprises, or at least until after the date when it would have been useful to them, that is, in raising donations, for example, in order to run campaign ads. I'll return to that example. In the summer of 2010, a heretofore obscure federal employee in the U.S. Department of Agriculture, Shirley Sherrod, lost her job because of some reported comments she made during a speech to the NAACP, indicating that she had seemingly acted in a prejudicial manner against a white farmer who had come looking to the Department of Agriculture for assistance. But it was not her treatment of the farmer that justified disciplining her. Instead, it was her description of the way she sees her job with the department. In her speech, she lays out very clearly what animates her: hatred of the haves and doing favors for the have-nots against the greedy property owners who have amassed their fortunes on the backs of workers who they must have treated unjustly, even if we don't have any direct evidence to manifest that. And I'll return later to that example. On the IRS example, though, this, I think, is a thoroughly illuminating example, especially as the story began to unfold this past spring. Part of the administration's response to the unfolding of facts concerning the scandal was to deny that it had anything to do with ordering such scrupulous examination of the targeted groups. We were led to think that the whole shebang was the result of some few, quote-unquote, rogue agents in the IRS field office in Cincinnati. Why that happy Ohio city was chosen is somewhat unclear. It likely would not have been singled out had the scandal broken during the election year of 2012, when Ohio was so central to the president's re-election chances. One response, though, another response on the part of the administration to the breaking stories, week after week, one story after another, was in fact a statement that its harshest critics would have to consent to. And that is, as the administration argued, in a government that is as big as ours, it would be impossible for the chief executive to be able to oversee everything that is done by administrators in Washington. Yes. Indeed, that is certainly true. And it is good to see that the obvious can still be identified in Washington. But we might ask what conclusions we should draw from this. That is, if we accept this account, do we just excuse the president from the responsibility for administering the law, or, alternatively, might we be compelled to rethink the nature of the relationship between the chief executive and the bodies that are authorized to administer and enforce the law? Let me be perfectly clear, as our president likes to say. The Internal Revenue Service is a bureau within the Department of the Treasury. The Secretary of the Treasury is a member of the President's cabinet, meaning that he reports directly to the chief executive. The IRS, then, is an entity wholly contained within the executive branch. No one could conceivably think that the IRS is not responsible in principle to the President, or that it does not receive its direction from the President. But that is what the President has asserted. Well, what evidence is there that the President does not have control over the administrative bodies within the government? Is it not the case that the President is the head of the executive branch, and these executive branch and other independent administrative agencies report to the President? Well, actually, yes and no. So allow me now a brief excursus into the details of a few court decisions that I hope, will illuminate the path to our current impasse. An examination especially of a couple of key cases dealing with presidential appointment and removal power, I think, indicates the trajectory of the path we have followed for well over a century in this regard. So I'll note three cases. One, 1908, a case called Shurtleff versus the United States. The Supreme Court held that a customs officer could be removed from his position by the executive. Shurtleff had argued that because his position as a customs officer did not have a designated term, length of the term, then it should be understood that he held that office for life. This sounds unbelievable today, but of course this is exactly what every civil servant holds their office for today, is for life. The court, a bit incredulous that Shurtleff would claim the kind of tenure that only a Supreme Court member could possess, rejected his claim. In 1926, in Myers versus United States, the court seemed to expand that view. Here, holding in favor of the authority of the president to remove Myers, a first-class postman, even though Myers' position was one with a fixed term of office. The courts are, so Shurtleff, no fixed term, president can remove him. Myers, there is a fixed term, president can remove him. The court's argument was that, in Myers, 1926, if the president is going to be responsible for carrying into execution the law of the land, he must have subordinates to assist him in doing that. And to be effective in carrying out the law, those subordinates must be responsible to him. But that reasonable conclusion was not to hold up for long. In 1935, in Humphrey's Executor versus United States, the court upheld the constitutionality of the Federal Trade Commission and protected the commissioners of the FTC against removal by the chief executive without cause, that is, without reason. This seemingly insignificant case turns out to have been extremely important, though, as we shall see. The court, in issuing this opinion, which it did the very same day it issued the Schechter-Poultry decision and Louisville versus Radford, both striking down major pieces of New Deal legislation, the court saw itself in Humphrey's Executor as defending the older constitutional order, in controlling the delegation of power by Congress to the executive, and in striking a blow for local control. But when you look at the argument that the court made in Humphrey's Executor, it really is striking. And I want to quote just a couple of brief passages. Justice Sutherland, in writing the opinion for the court in Humphrey's Executor, describes the responsibilities of the Federal Trade Commission. And he tries to distinguish what the FTC does from what the executive does, justifying then, in his view, the necessary independence of the commissioners. So this is the way he described it. The Federal Trade Commission is an administrative body created by Congress to carry into effect legislative policies embodied in the statute in accordance with the legislative standard therein prescribed. Ordinarily, readers of American constitutional law and American political history might draw the conclusion that that's what the executive does. Congress passes a law and the president executes it, but not when it comes to the FTC. Such a body, Justice Sutherland went on, cannot in any proper sense be described as an arm or an eye of the executive. Its duties are performed without executive leave and must be free from executive control. That, of course, is because that's what the statute says. And then he says in the most famous line from Humphrey's Executor, in administering the provisions of the statute in respect of unfair methods of competition, that's what the FTC was designed to address, that is to say, in filling in and administering the details embodied by that general standard, Congress just gave a general standard to the FTC to deal with unfair methods of competition. Sutherland says, the Commission acts in part quasi-legislatively and in part quasi-judicially. I love the in part. See, it's not enough just to act quasi-legislatively and quasi-judicially. It has to be in part. And notice, of course, what he's left out. It doesn't do anything executive. So therefore, it should be at leave from any kind of executive oversight. Now again, an ordinary reader of the Constitution, American political history, might draw the conclusion that what he's described here as the activity, the proper activity and domain of the FTC is actually what the executive does. But that's why Sutherland and the court here has to distinguish what the FTC does from what the executive does. And he does that in part in this way. That is, in order to defend the legitimate freedom of the FTC from executive oversight. And so he puts it this way. To the extent that the FTC exercises any executive function as distinguished from executive power in the constitutional sense. What's the difference between an executive function and an executive power in the constitutional sense? Right? To the extent that it does that, it does so in the discharge and effectuation of its quasi-legislative or quasi-judicial powers. Again, the court does not make clear what the distinction is between an executive function and an executive power. But what it is clear on is that it wants the FTC to be out of the control of the executive. Now, why does it do that? Well, the court majority, in handing down Humphrey and Schechter on the same day, apparently thought it was striking a blow at the centralization of governmental power and at the extent of power being sought or already being exercised by Franklin Roosevelt. Here, for instance, is Arthur Schlesinger Jr.'s account of what occurred the day the rulings were handed down. So this is from Schlesinger's work, The Age of Roosevelt. He describes it this way. As the crowd in the Supreme Court, as the crowd dispersed, a page tapped Tom Corcoran on the shoulder, Corcoran a major advisor to FDR, and asked him to come to the robing room. Corcoran entered to find the justices disrobing. Brandeis, holding his arms aloft for a page to take off his robe, looked to Corcoran for a moment like a black-winged angel of destruction. If only. The old, that was me, that's not Schlesinger. The old justice had rejoiced in Hughes's opinion. Hughes wrote the opinion for the court. He had noted on the draft, the draft he sent back to Hughes, this is clear and strong and marches to the inevitable doom of FDR and the New Deal. Now, he said triumphantly to Corcoran, this is the end of this business of centralization. And I want you to go back and tell the president that we're not going to let this government centralize everything. It's come to an end. As for your young men, that is the New Deal brain trusters, you call them together and tell them to get out of Washington. Tell them to go home, back to the states. That is where they must do their work. And Schlesinger concludes his account, this was the Black Monday of the New Deal. But of course, in the end, it was not the end of the business of centralization, unless one means the centralization of power in the hands of the executive. It's difficult to see how the rejection of delegated powers in Schechter and denying the president removal power over federal trade commissioners, as in Humphrey, can be seen as decentralizing power, and how sending aspiring political activists back to the states can be seen as a legitimate alternative to congressional delegation of power. There is certainly a kind of decentralization that is going to take place in the aftermath of these decisions, but perhaps not what all of the justices had in mind. The decentralization of power that takes place in the wake of Humphrey's executor, one might argue, takes place within the government. A decentralization not animated by a principle of federalism, but by a desire to insulate federal administrators from the heavy hand of the president. A common analysis, let me say a little bit more about that. A common analysis of American political development in the post-New Deal era focuses on the growth in the size of the government, the bulk of which, of course, is found in the executive branch. While one would expect such growth to occur there, given that the legislature and judiciary are more naturally confined and not enforcement bodies, it would be a mistake, I think, to conclude that the growth has resulted simply in an expansion of executive power, or what we came to call, after Arthur Schlesinger, the imperial presidency, or what we like to call today, at least during the Bush administration, the return of the imperial presidency. I haven't heard any talk about that for the last 5 years. What seems to have been often neglected, though, in presidential analysis, is that the creation of what we might call a wall of separation between the executive and the quasi-legislative, quasi-judicial agencies exercising executive functions but not executive powers serves largely as a limit on the executive, at least on an executive with designs on reconstructing the political order through reductions in the size and scope of the federal government. One might suggest that this principle is even at work in attempts not to necessarily undo governmental programs, but simply to reconstitute them. Perhaps this was the fate of President Bush's attempt to introduce Social Security reform in 2005. The new arrangement, that is, in the post-Humphreys executor, post-New Deal era, the new arrangement will likely accommodate significant increases in the reach of governmental power, though, such as can be found in creating the Department of Homeland Security or in expanding the role of the Department of Education through a No Child Left Behind bill or the Affordable Care Act. It may be for reasons like this that Sidney Milkus, for example, in his Presidential Greatness book, asserts that FDR is the last of the truly great presidents, and that it is precisely because of the very success he enjoyed that subsequent presidents have found it impossible to elevate themselves to the level of greatness. So where are we today? When you combine stripping away removal power from the president with another phenomenon, which I've mentioned briefly, the delegation of power to the executive, a dangerous perfect storm arises. Congress's delegation of power, in the modern sense, seems to be articulated clearly in an 1892 case, Field versus Clark, in which Congress authorized the president to take a course of action when he judged it appropriate to do so. In other words, what Congress is saying in the bill that led to the case, what Congress is saying is we're not going to make a policy choice, but instead we're going to leave that choice up to the executive branch. And Congress has thus routinely delegated more and more authority to the executive, as has been suggested throughout the 20th century. But it has then, in actions embraced by the Supreme Court, systematically removed the authority of the executive to control the officers who are charged with executing the law. So, Congress can avoid passing real laws, which it does, passing real laws, which passing of real laws would require it to take responsibility for the policies which are being enacted and implemented by the bureaucracy. But it then increases in size and scope the reach of the bureaucratic agencies, right, by delegating that power to them. Then it removes from the executive the authority to control the direction of the office and the actions of the office holder. But it goes further, of course, that is, Congress does, and exercises control itself over the agency or department through a variety of means, in particular the legislative veto, legislative oversight, and most importantly, the budget. But the president still has some freedom. Freedom to add to the oppressive measures that Congress and the administrative agencies have visited upon the unsuspecting public. And this is especially the case when Congress and the White House are controlled by the same party. The fact that the chief executive can, as we saw with the IRS scandal, exercise significant control when he wishes to do so, but distance himself from the felt excesses of administrative authority over the legal and regulatory regime is not a result of chance. And Congress has no incentive for cleaning up this arrangement. Why would it? As things now stand, members of Congress can pass broad pieces of legislation about which they can make large pronouncements about how responsible they are, but distance themselves from making the difficult policy choices that must be made by passing such authority on to agencies who are going to implement the bills they have passed. Many cackled, for example, when, in discussing why Obamacare had to be passed, then House Speaker Nancy Pelosi said that we have to pass the bill before we can know what's in it. That, in fact, is true. That's true. Why? Because the substance of the bill is really going to be understood only when the agencies get their hands on it and begin to implement the broad demands of the bill. Witness, for example, the controversial HHS contraceptive mandate. This became law, of course, only in the way we loosely refer to agency rules as law. The Affordable Health Care Act gave power to the Secretary of Health and Human Services to come up with the rules and regulations regarding health insurance. And of course, every member of Congress can say, we didn't pass that. That came from HHS. So, Congress can distance itself from the details of legislation or its implementation when the public dislikes it, asserting that Congress, was not responsible for the regulation, but pledging to fight on behalf of its constituents to fix it. Better still, for members of Congress, administrative blunders are golden. Golden opportunities to intervene against a hated bureaucracy, allowing them to claim to be cutting through red tape to aid constituents, which constituents just happen to also be the very people who can re-elect them to office or donate to their re-election campaign. Far more important than one vote. Sometimes these constituents, of course, are referred to as special interests. But this being modern America, we're all special. It would never dawn on a member of Congress to reveal to the poor voter back home that the agencies are largely under the authority of Congress, and that the muddled mess the constituent sees is actually a brilliant game plan for maintaining power and holding on to their office. Okay, my conclusion. I gave a talk recently where, in the question and answer period, a woman, clearly frustrated with the trajectory of contemporary politics, raised the question, what do we do if we can't trust the Constitution? I tried to comfort her with the response that, well, it isn't the Constitution that can't be trusted, but the people who are entrusted with exercising power under the Constitution who have betrayed its principles. In the end, I recognized that in practice that is really little or no comfort. To return briefly to Ms. Shirley Sherrod. Ms. Sherrod made clear in her public address, the one that got her such notoriety, what animated her movement into public service. And I quote her, "I grew up on the farm, and I didn't want to have to do anything with agriculture. But there are jobs at the USDA. And," she said, "you've heard a lot about layoffs. Have you ever heard of anyone in the federal government losing their job? That's all that I need to say, okay?" See, a federal job is a federal sinecure. And as you can see from her comments, it didn't really matter to her whether the job was with the USDA, the FBI, the FCC, or any kind of newly formed agency. Perhaps you haven't heard about the latest one. I think the title is the U.S. Bureau of Collecting Humongous Private Information that we can leak on the internet to our political allies in order to punish those who oppress us, like those evil budget sequester advocates. Okay, I made that up. But you know very well that the existence of such an agency is just around the corner. We would like to know, and we are routinely told, that there are thousands of public servants who are career officials, who are dedicated to the genuine good of the country, and who are there in Washington or in some hinterland like Siberia, maybe Cincinnati, because they have hearts of gold. We're led to believe that the ranks of federal employees are filled with characters of sweetness and honey. And perhaps you know someone like that. Perhaps you have a relative, even a parent like that. Perhaps it might be you someday. And surely there are some such folks, and many of them. Unfortunately, when you scratch the surface of so many others, you find not Clara Barton, but Shirley Sherrod, or this year, Lois Lerner from the IRS, who sees her calling as a public servant in defending her allies and punishing her opponents, and using the force of her position to serve the interests of those she aligns herself with politically and ideologically. So, to return to our theme of the day, what does this have to do with the Constitution? The answer, quite frankly, is almost nothing. That is, the way our government operates today has almost no connection with the system the framers designed, other than the fact that we still go through the motions of calling branches of government by the quaint names of the legislature, executive, and judiciary, even when so much of what they do is only tangentially related to the terms used to identify them. Students often complain that once they learn about how our government actually operates, they are depressed. And they want to know what they can do about it. Well, as the saying goes, the first step in recovery is recognizing that you have a problem. Once we acknowledge that, we can then begin the long process of restoring our Constitution. That first step perhaps can be found in answering the question, who owns the Constitution, by saying, we do. Not Congress, not the President, not the court, and not career bureaucrats looking to broker deals for their political allies and collect a handsome pension. And remember, in the end, to look at the bright side of things. It could be worse. Imagine if the IRS, for example, had access to your medical records. Thank you.